Hi, folks. Welcome to Crisco's Corner. Breaking news, breaking news, breaking news, breaking news. Supreme Court shoots down New York rule that set high bar for concealed handgun licenses. The court ruled in its first major gun case in more than a decade. I live in upstate New York. I live in New York. And we have one of the most restrictive gun laws in the country. Even probably, I think in some ways, worse than California, New Jersey, New York City. Let's read on. The Supreme Court Thursday ruled 6-3 that New York's regulations that made it difficult to obtain a license to carry a concealed handgun are unconstitutionally restrictive, and that it should be easier to obtain such a license. The existing standard required an applicant to show probable cause for seeking a license. Since when did you need a probable cause for exercising your constitutional right, your God-given constitutional right? Now, I'm not going to read this whole story. I'm going to leave a link in the description so you want to read the whole thing. And allowed New York officials to exercise discretion in determining whether a person has shown a good enough reason for needing to carry a firearm, stating that one wished to protect themselves or their property was not enough. And there you have it. It's as simple as that. You don't have to have a reason to prove to the government your God-given right to carry a firearm. In this case, petitioners' response agreed that ordinary law-abiding citizens have a similar right to carry handguns publicly for the self-defense. We too agree and now hold, consistent with Heller and McDonald, that the Second and 14th Amendments protect individuals' right to carry a handgun for self-defense outside the home. And that's the key part, outside the home. Because many of these states and jurisdictions say, yeah, you have a right to a gun in your house to protect yourself, but not outside. Justice Clarence Thomas wrote in the court's opinion, good for you, Justice Thomas, because the state of New York issues public carry license only when an applicant demonstrates a special need for self-defense, we concluded that the state's licensing regime violates the Constitution. Exactly right. They can't appeal this. There's nowhere to go. The case New York State Rifle and Pistol Association, Inc. versus Bruin was the first major gun rights case before the Supreme Court in more than 10 years. During arguments, it seemed likely the court's conservative justices would rule against the state. Why isn't it good enough to say I live in a violent area and I want to defend myself, Justice Brett Kavanaugh asked. In a similar exchange with Justice Samuel Alito, New York Solicitor General Barbara Underwood recognized that if an applicant stated that they leave work late at night and have to walk from a subway station through a high-crime area to get home, that person would be denied because they did not cite a specific threat. How is that consistent with a core right to self-defense? Alito added, stating that this is at the core of the Second Amendment. Considerers did indicate that it would be reasonable to have limits on where one could bring a concealed firearm. Well, that's a different issue for a different time. How is that consistent with a core right to self-defense? And the answer is, it isn't. So, Red, this is a great ruling. I wish it was more clear, but better take 3/4 of a loaf than none, and especially in a state like New York. Now we're going to see how Hochul, the appointed governor, as I call her, unelected governor, who's running for re-election, let's see what nonsense she's going to spout, because she's got to throw raw meat at her base, the anti-gun people. So we're going to have to see. Anyway, folks, great news for the Supreme Court. We're still waiting on the Roe v. Wade and other issues the court has voted on this year. But this is definitely a step in the right direction. And until next time, folks, goodbye and good luck.